new tax law took away many of the deductions that we used to take, but the charitable deduction is still going strong. Do your charitable giving the smart way with a donor-advised fund from Donors Trust. Think of a donor-advised fund as your personal charitable savings account. Donors Trust is unique among donor-advised funds because it was built with you in mind. People committed to limited government and free enterprise. Download your free prospectus at donorstrust.org/bachelor to see how Donors Trust can help you minimize your taxes and maximize charitable impact. I'm John Batchelor, Malcolm Hoenlein, Conference of Presidents, major American Jewish organizations. And we turn to a story in the news in California, but it's global news, about a decision. San Francisco State University. The decision is integral to a success for Brooke Goldstein, an ally of Malcolm's and our colleague of ours these many years. Brooke Goldstein is part of the Lawfare Project that Malcolm works with very carefully. And this turns on the question of discrimination against Jewish and Zionist students at San Francisco State University. I welcome now someone to explain, because this is a legal matter, Ross Kramer, a partner at Winston Strawn. Ross, a very good evening to you. San Francisco State University has now admitted that it will correct discrimination against Jewish and Zionist students. Please explain to the audience the significance of this, San Francisco acknowledging their bad acting. Good evening to you.
Good evening. Thank you for having me. So this case really was an important and groundbreaking case. When we were working on this case, we had not been able to find a model for the settlement that we wanted to achieve if we didn't have to go to trial. And that settlement was very pointed in the fact that the university had to acknowledge that for many Jews, Zionism is an important part of their identity. And that when Jewish students are excluded from important school events, the school can't use political discrimination as an excuse for what is clearly religious discrimination against Zionist Jews.
So what we're talking about here is something that's been developing and is in evidence around the country. We've talked about the boycott, divestment, sanctions movements, but this is really several layers above that, several levels above it. And you're talking about some very serious manifestations where pro-Israel speakers couldn't be heard, where Jewish students, and the judge acknowledged it, clearly felt endangered and threatened, and for good reason, because there were times when they were physically endangered and set upon. And the settlement that emerged in a university that initially said they weren't going to do it, but seeing the immense work that you at Winston & Strawn and the Lawfare Project and their lawyers and the people who have worked on this for so long, the tremendous effort really paid off because you had such a strong case against the university that they settled with virtually everything. And maybe you could tell us some of the components of that settlement beyond just the acknowledgement of the threats to the students and the failure to respond to them properly.
Yeah, absolutely. Beyond that statement from the university, which really was key, another very important part was that the university, which has a long history of complaints of anti-Semitism, would have to hire a coordinator of Jewish student life. And that would have to be a funded position. It would have to be given an office on campus. Also extremely important was that the university going forward wouldn't do its own evaluation of its policies and practices and training or its own evaluation of student complaints. They would have to retain at their own cost an outside monitor who would handle all those things and issue public reports about whether the school's practices and policies were up to best practices. And any future discrimination complaints would have to be evaluated by an outside qualified person, not someone inside the university. All of those components were very, very important to us, and really there was no model out there for this kind of resolution with a school. We had to make this up on the fly as we were going.
But they also allocated money to support educational outreach efforts to promote viewpoint diversity, unlike what we commonly think that it would include not only but pro-Israel and Zionist viewpoints and inclusion and equity on the basis of religious identity, which will benefit all students, not just Jewish students, and put these extremists, I think, on notice. And frankly, it has to put every president of a university in the country who chose to ignore this, didn't want to be bothered, turned a blind eye to discrimination against Jewish and other students, and often allowed extremist voices on the campus to dominate unfairly and in a restricted basis, that this will be a landmark change for them.
Well, that's what we were really hoping to do. This was a case that was brought by two individual students at San Francisco State University, and any settlement could only bind that university and the CSU system. But the idea for us was to create a model where there wasn't one, to make something available to others who might run into this kind of issue in the future, both at San Francisco State University and throughout the country and throughout the world. And I think by achieving that, we've given at least hope to a lot of professors at different universities, a lot of students throughout the world who may be suffering the same kind of harm, but may not have the faith in the judicial system to bring a case and to see it through almost to trial.
And I'm sure that many people in the audience, John, are saying, well, why would Jewish students be subject to the discrimination? The fact is that 60% of hate crimes in America are against Jews, 15% against Muslims, and yet we're against all forms of discrimination and bias. But there has been a special problem in regard to the anti-Israel, and this does not mean criticism of Israeli policies. Here you're talking about something much more fundamental and serious, and I think that is what you are trying to address.
Absolutely. I mean, this statement says by the university essentially that the next time a student or a student group voices a support for Israel in Israel's right to exist and right to defend itself, if people want to then discriminate against that student or that group, they can't do it under the guise of political discrimination. They can't say, oh, we're excluding them because they're Zionists or because they support Israel. What this settlement did is link those things together in a public statement from the university so that going forward, discrimination on the basis of Zionism or support for Israel will be linked to religious discrimination.
Is there reason to believe that other universities, other campuses where we can think quickly where this has happened before, that they're going to learn from this and not wait for a case to be brought against them?
Well, absolutely. I mean, we've already received, and especially the Lawfare Project and Brooke Goldstein have already received calls from rabbis throughout the country, from professors of Jewish studies at schools throughout the country. And I'm very, very gratified right now because it seems like our hopes for this settlement, that it wouldn't be limited to just this school and just these two students, are really being fulfilled.
And you're saying that the reason that you had to resort to the court was because the universities who were approached to settle it within the normal sphere of the campus apparatus refused to do so and refused to acknowledge this discrimination and discriminatory behavior against...
Well, this case...
Yes.
I was just going to say, I'm sorry to interrupt you. I was going to say this case is a perfect model for that because what happened was these students did bring an internal administrative complaint, and it was reviewed by an employee of the school. And predictably, that school employee found that there was no religious discrimination here, even though a Jewish student group and Jewish students were excluded from this school event. So what we tried to do here is ensure that future complaints like that would go to an external person, a disinterested person. And I think that's so important for internal school complaints. And in a school like this, where it just wasn't going to be given the appropriate level of gravity, resort to the court system really did work.
But why did Judge Orrick, who at one time said it failed to show deliberate indifference to the discrimination by SFSU, what was different about this case now that would have led to a trial? We'd be experiencing a trial now, and in fact brought about the solution or resolution.
Well, I think we lost him, Malcolm. I want to ask you one final question, Malcolm. If people listening to this believe that they have a concern that something like this has happened to them, is the Lawfare Project?
Absolutely. You should write to the Lawfare Project. You can write to the conferenceofpresidents.org. We will refer to them. There are hundreds of lawyers across the country, by the way, many of them non-Jewish, including some who worked on this case, who will come in and help. We don't want any student to feel threatened and put upon and to be discriminated against, and many of them living in fear.
We thank Ross Kramer, a partner at Winston Strawn, Malcolm Hoenlein, Conference of Presidents. We thank Brooke Goldstein of the Lawfare Project. I'm John Batchelor.